map now. Because we can't draw that map, we can't possibly do any of the other studies required and provide the information necessary to perform this review. Dona County at that time said no. They took a vote, and I believe it was a 3-2 vote. Happy to check the record if anybody remembers it otherwise, to continue on and do the hearing of this matter on that date. And the hearing went forward, and the hearing determined that we, P. Ghost and Mary Gonzalez, didn't prove conclusively that we could provide the services in the same amount of time that the city of Sunland Park could. And in looking at that, Your Honor, a couple things are of note that I believe show the fact that there was, the decision was arbitrary. In the decision, the county stated that the incorporators must show that they can provide their own municipal services and not contract with other people to provide those services, which, as a matter of fact, Sunland Park does not do. They have many contracts with other entities and other service providers to provide those municipal services in that long list that's in 3-2-1. And therefore, the county was attempting to apply a standard to us that no other municipality would have to comply with. And there is nothing in the state statute requiring that. It simply creates a new burden of proof that we have to prove conclusively. And we would submit that it was not the county that needed to determine that anyway. Once again, the county seemed to want to decide this themselves under 3-2-3 without following the normal process of 3-2-1 for any incorporation. And we would submit that the county is not in a position to do the analysis required by the incorporation team organized by the State Department of Finance. And the reason that statute's there is because no county and no citizens on their own are able to create such a review, and it's therefore done by the state. Did not happen here. We do not believe that this incorporation can go forward until the annexation decision is rendered, for the simple reason that we can't meet our burden of the state statute to begin an incorporation, because we can't know what the map's going to be until we know that this donut hole of any annexation that was illegally begun after we started our incorporation are going to continue to exist or not. We then, of course, Your Honor, would have to consider, and we believe the state needs to consider, what happens in a situation like this when there has been a 6-year, now 7-year gap between the initial application through a petition for incorporation and a review at this point. We would seek that order of the court that the counties submit this question along with the petitioners to the state, that they convene a incorporation team and determine what evidence is necessary now at this point, because you can't ignore the fact that 6 years have gone by. So are we supposed to, and is the county supposed to look at that moment in time when the incorporation was filed, or does it have to review the current conditions on the ground? So after the annexation case is concluded, we would have to then begin this process of looking at how the incorporation should proceed. And we would submit that this initial determination by the county back in 2015 that you have to stop because you haven't met the requirements of Section 3-2-3B 2 and 3, they believed that that was essentially a motion to dismiss the incorporation at that point because we didn't meet the initial threshold requirements. So there was no submission to the state of this incorporation to review through the State Department of Finance, as all incorporations have to be done, because that initial threshold question wasn't answered. So we believe that this was simply not done correctly, was not done properly under the law. It was arbitrary, and it was not supported by substantial evidence by the county, because the county didn't even know what map they were reviewing because the annexation was still pending. I'm not going to belabor this, Your Honor. I think that the issues before the court have been well outlined by the parties. They've been argued previously under previous motions, and I believe that there are no questions remaining on the law. I think the question in regard to the prior jurisdiction is with the Supreme Court. We don't have to decide that. I think your decision today, Your Honor, is simply, did the county commission properly handle this incorporation application when it came back to them on remand? And we would submit, for the reasons I just stated, that they did not at all handle it properly. They attempted to decide themselves whether or not these governmental services could be timely provided. There had been no analysis of the ability of this incorporating entity to pay for those services, because there had been no analysis done by the state. That's not done by the applicants. That's not done by the county. It's done through the State Department of Finance, because it's a very complex question. So that process should be followed in this case. I don't think the creation of Section 3-2-3 threw out statutory provisions in 3-2-1. There's nothing indicating that that occurred. And the only way to read these two statutes together is to require this different burden of proof to be followed by the state incorporation team. And then they give a yes or no answer to the county as to whether that the burden has been met of those statutes by the incorporators or not. It isn't a decision for the county. So with that, Your Honor, I would stand for questions from you. I do want to reserve the half-hour remainder of my time to clean up any issues that have been brought up by the other parties in this case, or answer questions you have. Thank you.
Mr. Adio, I don't have any questions at this time. Who's going to begin for the appellee? Is it going to be you, Mr. Gooden?
Yes, Your Honor.
Okay.
All right. So, Your Honor, we heard for the first time a new argument here that I've never heard before, and that was that it's the review team and not the Board of County Commissioners that should have made the determination as to who could provide the municipal services faster. That's the first time that argument has been raised. It was not in the briefs. Not have a great opportunity to review that. However, it does set out in the duties of the Board of County Commissioners when they get these petitions on what it is they're supposed to do. And if they're in an urbanized area, then they have to go to the 323 section to make sure that that's been complied with. The section 321 subsection that deals with the review team, that was added in 2013. So well after the other incorporation statutes had been put in place. That's a new argument I've not heard before, as I said, but it is still, it does place upon the Board of County Commissioners to review these petitions. And that is the Board of County Commission that if the petition is proper, will call for the election. It would would be our interpretation that the board does its review. If it finds everything to be proper, that it would then at that point send it to DFA for their review and their approval. So that's our position as to that, and that kind of leads back into the arbitrary and capricious argument. It was implied through this argument that, well, the BOCC had their mind up, didn't want this to incorporate, and so when it got remanded, so they made their decision initially back in 2015. It got appealed, got overturned, and well, so clearly the board must have never wanted this to happen. So despite the fact that the Court of Appeals said, remanded it to reconsider, that they were going to come up with the same result regardless of whatever evidence may have been presented. I think that's a disingenuous argument, I think, Your Honor. The same argument could be made any time that a case is remanded to a judge to do something else with their decision. That if the judge came to the decision, and a lot of times those remands are to consider additional evidence, as you well know, consider additional things. And oftentimes the court will come to a similar decision after complying with the court's remand order. You could make the same argument then that a court, anytime they've been told to reconsider something, that they're just going to review or listen to the evidence, interpret the evidence in such a way as to uphold their prior decision. I think it would be improper to imply that towards the courts. I think it's improper to imply that to the Board of County Commissioners in this case as well. I think they did go back. They held a very lengthy hearing and have a very detailed order as to the issues as to the municipal services plan and what evidence was presented in support of the position by PGOST and in support against PGOST, and they put those in. So I think just kind of that insinuation that, well, the board was going to deny this regardless, and so they were just acting arbitrarily and capriciously because they were going to get to the result they wanted originally, and therefore the remand was really, remand hearing was just some sort of a going through the motions and actions. There's nothing that would support that. Going to the issue as to the continuance that was made here. The argument is made that, well, they could never, that PGOST, Mary Gonzalez, could never properly go forward with this hearing and this presentation because they didn't know what the map was. Again, they had a petition filed. The petition was filed in 2015. That petition has a map. That is the area that they sought to incorporate, and that is still the area that is being sought to incorporate. There have been some issues that have come to pass. There have been some incorporations that intrude into that area. Those are before the court. However, it is still that map, that area that was originally petitioned. Would be my position that they can't come in and change that map at this point in time, because when people signed that petition, they signed that petition on the basis that that entire area that was in the petition, that was described in the original petition, what was going to be incorporated, or they were seeking to incorporate. It is possible that a signator on that petition could say, if it's not that entire portion, I'm not in favor of this and I would not sign this. I want to make sure as a signer of this that area that's owned by Socorro Partners that they want to develop is included, because in order for this to be viable, in order for this to have a proper tax base, we need that property developed in our city of Santa Teresa. I don't have any evidence that anybody specifically says that, but that is a possibility. And so therefore, if you take areas out of that map area, it is not what the signatures on that petition were petitioning to have incorporated. I agree with one thing. If the Supreme Court ultimately allows the the annexation of that particular area to go forward, it creates problems, potential problems with this proposed incorporation. But that's a bridge I think we cross if and when we get there, not at this point in time. And then going back then to the Well, we couldn't properly present a hearing, so there was not substantial evidence to present to support this decision. Again, this was filed in 2015. They got the remand order, came out in December of 2020. This hearing took place in June of 2021. They knew that this was going to come back for a hearing. They knew that they were going to have to present to the board information about their proposed services plan. This was first going to be scheduled for hearing in April 2021. And Mr. Audio in his brief says, well, there's nothing in the record that supports that. There is something in the record that supports that, but I will tell you kind of what happened. We were looking, we're drafting the agenda for the county commission meeting. It was to be on the agenda in April. I got a call from Bob White, who at that time was representing Bigos and Mary Gonzalez. I don't know exactly what the relationship with Mr. Audio and Bob White was Robert White at that point in time. I know that they had been working together at some point, and they may have worked together on this case at some point. At that particular time in April of 2021, I don't know if they were associated with each other or not. I think maybe not, but in any event, they had worked together on this. Mr. White requested that be continued, that we not do it in April, that we do it at another time. Of course, he asked that it be postponed indefinitely until the petition or the issues regarding the annexation were completed. And we said, no, we need to do it sooner. So we did it 60 days later. Now, what is in the record that supports that? Because Mr. Mr. Audio states in his brief that there's nothing in the record that supports that. There is, however, in the record, there is on page 22 of the record, the email that I sent to Ms. Gonzalez saying, we're going to proceed. This was scheduled in April and it's been postponed. And then also there's some mention of that in the transcript or in the recording of the meeting itself. First at 1 hour and 11 minutes and 25 seconds into there's discussion by the chairman at that time, Commissioner Sanchez, that we've been waiting for 60 days. He also states at 1 hour, 12 minutes and 5 seconds approximately, and it was supposed to have happened in April. And then there's also discussion at just in that meeting, 14 minutes and 50 seconds roughly, that it was originally scheduled for April. So that is within the record itself. So there was plenty of time to have addressed this issue, to have brought this together, and to say arbitrary and capriciously just that it was not granted the continuance. I don't think that is supported. There was ample opportunity. And again, going back to the standard for arbitrary and capricious, it is to determine whether in reviewing the whole record, it has been unreasoned action without proper consideration or disregard of the facts and circumstances. And these cases are cited in my pleadings to that effect. It took over an hour, almost 2 hours, it took about a little over an hour and 15 minutes discussing the issue of continuing this hearing or not. There was a lot of back and forth, a lot of discussion, reasons why. I don't think at that time you could come to the conclusion that it was arbitrary and capricious, that it was done without proper consideration or disregard for the circumstances. As the courts have said, a ruling is not arbitrary or capricious where there's room for two opinions, if it is exercised honestly and upon due consideration, even though another conclusion might have been reached. And again, that case, Mass Enterprise Production, is cited in my brief as well. So as to the arbitrary and capricious, I don't think they've met the standard to come to that conclusion. Again, the second argument that was made, I think only briefly touched on in the oral arguments today, is that it was not supported by the substantial evidence. And their whole argument is, well, we couldn't present evidence because we didn't know what the map was going to be, and this should have been done by the board, by the review team, rather than the Board of County Commissioners. The order from the Board of County Commissioners is very detailed. Each of the items that they set forth in their municipal services plan in their petition were addressed very specifically. And what evidence was provided as to who could provide the service, whether or not the residents of the area proposed to be incorporated could provide the services faster than the city of Sunland Park. And it was very detailed in setting that basis out. Mr. White says, well, we said that that they're contracting for those services wouldn't be allowed in this case when anybody else could contract. That's not what the order says. When they were talking about the contracting and the evidence that was presented, there was discussion that, well, we could contract with the, one of the items for police services. Well, we could contract with the Dona County Sheriff's Department to do that. There was no evidence that there was ever even any discussion with the County Sheriff's Department about providing those services. We could contract with the city of Sunland Park and Dona County to provide fire services. No discussion ever had that they brought forward anything, that there was any discussion about actually entering into such a contract. And on, there was a lot of that. Then, well, we could contract with somebody to do this, but is there a contract in place? And some of those particular items, fire services, were, for example, one of them where they said they could contract, one of the people they wanted to contract with was the city of Sunland Park. Well, if Sunland Park could do it to contract with, they can already do it. So therefore they did not show that they could do it before the existing municipality could. So I think that order is very detailed. I think it sets out very specifically the evidence that was presented, and it is, I believe, supported by the substantial evidence. The other argument, not in accordance with law, that's the one that changed a little bit that I mentioned before, that it shouldn't have been the board making this determination about the services, but it should have been the review team. It's our interpretation that if everything is found appropriate by the county commission, because they have a role in this process of determining is the petition accurate, is the map right, that then goes to the review board, and that was the statute that was passed in 2013, because there was concerns, I believe, by the legislature about some recent incorporations that had taken place. Now, they did not, and one specifically, I think, being Anthony, New Mexico. That one was different because it did not have an urbanized territory. And other incorporations now that have taken place throughout the state may not have had that urbanized territory issue to deal with that we have here. So the other argument that was made in the briefing about not supported by the law was that the burden of proof of conclusively prove that the residents can provide the services sooner than the existing municipality could. The argument was made there that this is just an inappropriate burden that they have to reach. We didn't set the burden; the legislature set the burden. And the Supreme Court in the 1990 decision, which has been cited regarding the attempt to incorporate Santa Teresa and the fight with them with Sunland Park at that point in time, the Supreme Court at that point even says this was meant to be a very high standard. They did not define what conclusively proved meant, but they just came to the conclusion that at that time it wasn't met. So we still don't know exactly what conclusively proved means. The Court of Appeals in that case had determined that it was more than clear and convincing. The Supreme Court didn't actually adopt that standard. They just said, we don't know what it means, but you didn't do it here. So the impossible or absurd standard, as he puts it in his as Mr. White puts it, excuse me, Mr. Audio, Mr. White's gone out of this case, Mr. Audio now.
I consider it a compliment.
So putting that in there, that I mean, it's maybe a very high standard, but it's what the legislature said. And so I don't think when the legislature sets that standard of proof, we can say that it's unattainable and absurd or not supported or contrary to law when they're held to that standard. Your Honor, I think that's really all I have on this case. I think my brief set out pretty detailed what our position was on most of these issues. And I think that at this point, we just need to move on with it, get a decision from this court and then move on.
Mr. Gooden, just with respect to that, I did have a question. The position that you're advocating is that the decision by the county commission should be upheld, and that does fully resolve the case, I think, this case, and whatever happens with the other case, with the annexation case, would have cause us no trouble. However, if for one of the reasons argued by the appellants, it was remanded, then there would be significant issues until the Supreme Court decided the prior jurisdiction question. Would you agree with that? I think you did briefly, but would you agree with that?
I didn't completely understand the question, Your Honor.
Okay, so you are asking today for the court to find that the decision by the Dona County Commission was proper, correct?
Correct.
And if that is done, it either renders the prior jurisdiction question moot, or we are certainly not affected by it any longer, correct?
We would not, our position is it would not be affected by it. I don't know that it renders it moot, because there's still an issue there. And I think this court could find that the BOCC's commission decision was proper, but there still comes back then the question as to whether or not the prior jurisdiction, whether Sunland Park had the authority even at that point in time to annex. And so you could, Your Honor, I think you could say that the Board of County Commissioners were correct, but then also if the Supreme Court says there is a prior jurisdiction problem, it affects their annexations and not this incorporation.
Okay. And then on the flip side, if the appellants carry the day and this is remanded to the county commission for one area of consideration or another, there are problems then at this point until the prior jurisdiction question is answered. For primarily if the Supreme Court says the prior jurisdiction, I think as has been argued, doesn't apply the way it is being argued, and that the annexation can proceed. If the annexation is allowed to proceed, that creates significant problems for the petition in this case. Would you agree with that?
That would be our position. Now, how that gets resolved, we'll worry about that then. But yes, I think it could create some issues with that petition.
And I guess prior to going back to Mr. Accio for questions, a couple of follow-up questions that I have, Mr. Marazzo or anyone else, did you have any additional arguments to make?
Yes, Your Honor. Spencer Edelman on behalf of the City of Sunland Park. And just to give you a heads up, we actually did talk, and Mr. Gooden was going to go first, subject to Your Honor, then me, then Mr. Marazzo was going to bat cleanup. But obviously, if you need to interrupt and have questions from this audio, let us know.
I can wait.
All right, thank you. Your Honor, I wanted to address three things, two discrete things that I had prepared for, and one that came up this morning with Mr. Audio's comments about 3-2-1. I think there are, as to that point, I think there are two things. One, that argument has been waived. It's never raised before. It's not in the record. It's not in the record below. I can't verify this because I'm a relative newcomer to this case if we come into my next piece, but I don't think it was raised because it wasn't addressed in Judge Bonhoeff's opinion in any way. And it certainly wasn't raised in any briefing before this court. So it has been waived. Even if it has not been, my off-the-cuff thought to that is that 3-2-3 as a specific statute dealing with urbanized territory governs over the general statute dealing with a petition. Again, I might be wrong, but that's my off-the-cuff thought, just based on hearing that the first time, which is also why the right answer here is actually that argument has been waived or should not be considered by this court sitting as an appellate court. The second point I want to address, Your Honor, is Your Honor's actually kind of touched on it, but in a different way than I had thought about it. And again, I'm a newcomer to both this case, and I'm not representing anybody in the annexation case, but obviously I've gotten familiar with that as well. And here's my suggestion, because I think there have been problems, because the question is, what is a final order and what is the impact of an order from a court, while then we wait for the next step in an appeal to happen. And what I'm ask of Your Honor on behalf of the city of Sunland Park, to avoid the limbo that we find ourselves in, is to make clear in any order, regardless of whether you find in favor of appellants or appellees, that it's a final order unless a stay is granted pending an appeal. Now there's the New Mexico Supreme Court case dealing with this is the Siegel v. Goodman case, 115 NM 349, in case you want to just look at it. And basically it gives, there's a 30-day period to file a notice of appeal, and then the Supreme Court has kind of built in another 30-day period to deal with a stay request if an appeal is perfected. And I think that's important. I'm just emphasizing that because it will help everybody. There are provisions in the statutes for stays on appeal, 39.3-22, and specifically here I think B would apply. And it requires, and here's where I'm coming at this from the city of Sunland Park, there have been, in addition to the annexation that has been appealed from, there have been other annexations. Every time there's been an annexation, the city of Sunland Park gets a letter from Mr. Atio's firm saying, hey, this is illegal, stop, this case has prior jurisdiction. If we are right, and let me just play this out in my scenario, Your Honor. Your Honor upholds the Board of County Commissioners' decision. The appellants make a further appeal, and they are unsuccessful. But during that period, because of these threats related to prior jurisdiction, a developer, Socorro Partners, or the city gets brought into further litigation claiming this is improper, look at this prior jurisdiction. And ultimately, this case is that Your Honor's decision is upheld. Again, I'm assuming, Your Honor, I'm not trying to prejudge. There are damages. And that's where 39.3-22B, that provision comes in for Your Honor to be able, Your Honor or an appellate court, to fix an appropriate amount of bond. And that's what should happen. Again, I know this is somewhat tangential, but just coming at this and looking at the kind of chaos that this has happened, I think it would be clear for benefit all parties to be sure that we are following the stay provisions. And I think Your Honor can get there by making sure that Your Honor's order, whichever way it is addressed as a final order. And then if the aggrieved party wants to seek a stay pending appeal, they can do that. The last little point on that I want to make, Your Honor, is it relates to Mr. Gooden's motion joined in by the county by the city for dismissal of provisional government of Santa Teresa. There is a provision for allocation of damages caused by an appeal that is ultimately unsuccessful. And that's where the true party in interest, the party taking the appeal, which is only Ms. Gonzalez, needs to be able to step up the plate or not. And a court on review needs to be able to assess those damages appropriately or not. And since the provisional government of Santa Teresa is not a proper appellate, they aren't in a position to deal with those damages. So just a little pitch for Your Honor to take under advisement Mr. Gooden's motion. Let's be sure we're going through this process with the appropriate parties. The last argument I just want to emphasize, Your Honor, briefly, is something that is addressed in great deal in the appeal. And it's this idea that the Board of County Commissioners should have postponed. It still would have been postponed if the requested relief had been granted, and that they weren't ready for the hearing on incorporation. The entire purpose of the appeal from the 2015 county decision was to get to this hearing that was held in 2021. Although they didn't know if that hearing would happen until the Supreme Court ultimately quashed cert and sent everything back down, that is what they were seeking the entire time. To then get what you want and say, no, we're not ready, we haven't had enough time, without providing any analysis or facts about what they have actually been doing or how, for example, they would use an additional 60 days or 90 days or whatever it is, that's a little bit confounding to me, Your Honor. You get what you want. You win this appeal. You send it back for a merits-based hearing in front of the Board of County Commissioners. And then you say, no, we can't do it. That is not an argument that should convince this court that the Board of County Commissioners did anything arbitrary or capriciously or not in accordance with law. That's all I have, Your Honor. Those are the 3 points I wanted to make. I'm happy to address any questions on those or on any questions in general.
Thank you. Mr. Marazzo, do I understand you're next?
Yes, Your Honor. Thank you very much. I will try to add and not restate arguments. I think it's been briefed fairly completely. There's a few things that I wanted to point out. One, just to say that we do have in our response to the statement of issues an additional argument not raised by the county or the city, which is that the decision as to when to have the hearing is not a final decision, which is reviewable under the statute 39-3-1.1. That statute only allows review by this court of final decisions, which are defined as decisions that resolve the issues in their entirety. There's a statutory definition of it. And the when to have the hearing doesn't get there, doesn't meet that. So there's that. I want to address the request for continuance because I want to, and I'm talking about the June 15, 2021 request for continuance. That is found in the record at page 18. And I think it's important to actually read it because it's actually a little different that's being described in the briefing by the petitioners in this case. Number one, the request is 1 page with no attachments, no evidence. The request is, first of all, made not by Ms. Gonzalez as a signature of the petition. The request is made by the Provisional Government of Santa Teresa on the Provisional Government of Santa Teresa letterhead. And then Ms. Gonzalez signs as president. That nonprofit corporation, as has been brought up in the motion to dismiss filed by the county, has no standing to request anything from the county below or from this court in this case. And just for clarity, the stipulated order that we submitted to the court, which originally scheduled the hearing for January 31st, we all agreed and stipulated that a final hearing on the merits and on Dona County's motion to dismiss would be heard today within the 2 hours allotted for this hearing. So I do think it's proper for consideration. But as it relates to the appeal and the statement of the issues of review, you have a request for continuance by a nonprofit corporation, which is not a resident of any area, doesn't own property anywhere in the area, and has no standing to request anything of the county. And similarly, has no standing to appeal or be here before this court because under 3-2-5, clearly that statute says the signers of the petition of a municipality can petition, may appeal any determination of the Board of County Commissioners to the District Court pursuant to 39-3-1. That corporation has an officially sounding name, but there is no such thing as a provisional government. If you read the statutory framework, the nonprofit will not become the municipality. It doesn't do anything. It will stay there as a nonprofit completely outside of this process. It has been in this process for too long. It shouldn't be, and it is time that it be dismissed. Again, back to the continuance, that's the only party that requested it. The other thing to note in that request for continuance is that it was sent on June 15, 10 days before the hearing. And therefore, as evidenced by the email from Mr. Gooding, which is at record page 22, there was insufficient time to bring it before the board
Hey,
of
Alex.
commissioners.
Okay. How about you? You feeling better?
Go ahead, Mr. Marazzo. I've muted the individual. Whoever is A. Chalice, if you interrupt again, I will have to remove you from the hearing.
Thank you, Your Honor. There wasn't sufficient time to hear that request that the hearing be continued before the actual hearing. So this is the equivalent of asking for a continuance on the date of trial. And so most courts would say that's too late. And certainly a review of that decision to say that it's too late, it's really hard to conclude that that's arbitrary or capricious. I concur that there's evidence to support that decision. The emails are there. And by the way, the evidence that's there at page 22 and also the letter from the city at page 20 and 21 of the record, it's very clear that the hearing was moved from April 30th to June 15th over the objection of the city and over the objection of Socorro Partners, which means that there was consideration of objections. There was at least an initial decision in the favor of the petitioners, and that can never be arbitrary or capricious. That's a well thought out decision, and at one point went against us. On the argument, I guess this is what it comes down to, that they say that they can't have a map unless the Supreme Court decides the annexation case. I think, of course, that's a circular argument, as I have expressed before in connection with the motion to stay these proceedings, is the identical argument that was made to this court to stay these proceedings, is stay these proceedings until the annexation case is decided. And I think that the job of this court is, of course, to review what happened below and to proceed with what, as was articulated, with what they always wanted, right? And what they wanted is to have that hearing. They did have it. The argument that it should be the review team, I also concur that it was not raised below. I have not seen anything in the record that the county was given an opportunity to look at that issue or that it was brought before them. And I will share with the court this issue of what happens if the annexation is good, is one that we explored at some length in connection with a possible resolution of the case. Is at some point we explored, well, what if you cut us out of the map, right? And we resolved it in some fashion by cutting out of the map and just proceed with some amended map. And there wasn't really any statutory basis for an amendment of the map once it has been submitted. And so I concur with Mr. Gooding, the map is what it is, and I think it's either going to be good or bad. And so if the annexation is good and, they were somehow entitled to incorporate, I think there's going to be a legal question at that point. Can they incorporate on an amended map? And I don't know the answer to that question legally. I don't think anybody does. I think that it's up to eventually a court, right? but certainly is not. It's an uncertainty in the future of a possibility that should not interfere or get in the way with the process of having the hearing and having this appeal decided, so that ultimately this case can be resolved. We're 9 years out on this process from 2015, and further delay and staying things, we don't think it's ever the answer. Another thing to add that hasn't been said before, but I do want to point out, in that letter on page 18 of the record, the only request that is made, the only request is that the current hearing be rescheduled from June 22nd, 2021. I think that's a typo, it's June 25. It says until 90 days after the Court of Appeals issues an opinion in the case. That is the only request that was made. There is no request, for example, to say, if you don't do that, then in the alternative, give us 30 more days to gather evidence. Give us 60 days to put together a municipal plan. Or we are in the process of doing X, Y, and Z, and we need 15 more days. There's nothing like that. So they never gave the county a chance to say anything on how much time they needed. Never notified the county of it. And so when they don't even do that, a decision by the county to proceed with the hearing cannot be arbitrary or capricious in our view. With respect to supported by the evidence, you have the city's report on municipal services. The record is 154 to 200. To a great extent, the county is performing a fact-finding function, right? So that's why in the cases, the review of this court has to be deferential to the county. And the cases say the court cannot substitute its judgment for the judgment of the county. So it's not to say here that we're going to see if there's agreement or disagreement with what the county did. If the county is supported by evidence, if the county's decision is supported by evidence, it has to be affirmed. And here, the county was free, for example, to believe entirely and rely on the city's report and to disregard the municipal services plan in its entirety that the petitioner submitted. The county could look at both and find one better, more credible, better supported by the propositions in there, and weight one and give one greater weight than the other. And that cannot be redone at this level. All evidence has to be looked at now in the light most favorable to the county's decision. And when you do that on this record, there is no question that the county's decision is supported by substantial evidence. With respect to the standard of review, there's a very interesting argument by the petitioners in this case that somehow the standard of review is not that they needed to prove that they could provide municipal services faster. There sort of seems to be the argument in the briefing that all they had to do is prove that they could provide municipal services in the same amount of time. Well, that's not correct. And I'm going to point the court to page 22 of the August 2018 Court of Appeals decision, which is the one that remands this case, which is the one that allowed them to have the hearing and directed the county to have the hearing. And there the Court of Appeals says, while the legislature has imposed the hurdle of requiring the residents to prove conclusively that the proposed new municipality will be able to deliver municipal services more quickly than could the existing municipality, we do not believe it intended to make the process unreasonable. So that standard, that direction is almost word for word what you find in the county's order. The county's order matches almost word for word identically what the Court of Appeals said they should go back and do, and which is what they did. And they did it correctly, in our view. The county correctly points out that a tie under this standard, a tie means the petitioners lose. If both parties can contract a service and both parties can provide it at the same time, that means the petitioners lose. That means that they did not prove conclusively that the municipality couldn't do it within the same period of time. Question is not, is that fair or not? This is supposed to be difficult. I think that's the statutory framework. It's you're competing with an adjacent municipality. And basically what the law is designed to do is to say, if you want to do that when you have an adjacent municipality and you don't want to annex, you have to prove that you can do it faster, and you can do it better. They didn't get there on any of the grounds. I think this is a pretty straightforward decision to affirm with them, what the county did, Your Honor. And I will stop at this point and also answer any questions the court may have.
Thank you, Mr. Marazzo. I do have two questions, Mr. Audio, and then I stand corrected by Mr. Marazzo. Quite obviously, in the stipulated order does say that this hearing will cover the motion to dismiss. I apologize that I skipped the caption and the paragraph, and I just looked at the allocation of time. So I will, after asking those two questions and giving you a little bit of time for a rebuttal, Mr. Audio, I will let Mr. Gooden address the motion to dismiss. Please make sure, Mr. Audio, to reserve out of your 30 minutes time to respond to the motion to dismiss. But the two questions I have relate to the argument that the statutory provision that you're arguing today was waived. That when was the first time? The argument today is that today is the first time that it has been addressed, that the actual review of the municipal services had to be sent, could not be reviewed by the county and had to be reviewed pursuant to 3-2-1 by a municipal incorporation team.
Your Honor, so the way this came up, and I apologize for the lateness of this argument, the way it came up is in my preparation for this hearing. It was a very strange case that began a long time ago, and I was in district court with Provisional Governor Santa Teresa and Mary Gonzalez in 2015 when all of this began. And the case was entirely focused on the interpretation of 3-2-3 because that was the ruling of the county. It had to do with the threshold question, did we meet that test? So that's what went up to the Court of Appeals and then ultimately Supreme Court, and then cert was quashed. And then when it went back to the district court, we were not at that time representing P-Ghost or Mary Gonzalez in district court. They were unrepresented. They were there pro se. And at that time, I do not believe that there was any argument about the proper process. They were just believing, and I think rightfully so, that the county was jumping the gun. The county was essentially saying, let's decide this now. As Mr. Gooden said today, let's decide this now because we'll take care of the issue of the annexation later. I just think that was wrong. And the neighbors and the residents of the incorporating area, who P-Ghost is made up of, that was their focus. They were required to put on their case, even when different areas of their incorporated area were now missing.
So there's some explanation for why the argument has not been made. Can you address whether or not that means it was waived?
I do not believe it's waived at all, Your Honor. We cited throughout our brief the requirements of incorporation of 3-2-1. And my realization, and I did come to it in preparing for this case today, that's the fact, was that all of 3-2-1 had to be followed in this case. That's why this case got sideways, was because the improper process was used by the county when it came back to them on remand. I don't think it's waived, Your Honor, because this, all we're saying is follow the state statute. I mean, that's not a new legal argument or it's a new legal argument, but is not a new issue that did not exist. Following the state statute is what we had asked all along through this case. But the parties are absolutely correct. It was not briefed because we were focused on the primary issue, which is, I wouldn't say the definition of insanity, that's a little bit strong, but is the definition of an uncaring view to say by Sunland Park, by the Socorro partners, yes, we did take part of this land away, even though we were told that by the county and you that was illegal, but ignore that. Just proceed. Just prove up your incorporation. Ignore the fact that the annexation happened and just deal with that later. I just don't see how that happens, Your Honor. So to your question, this is the first time it came up. I do not think it's waived at all. I think regardless of whether I brought it up or not, that was the county's duty in this case. And it's as simple as that. They had the duty under Section D to send this on for review and a determination if they believed this was ready to go forward, even though the annexation case was pending, then they would have had to send it through this process.
But I understand that you don't want it to be waived, but what happens if I send it back to the county? I agree with you. I send it back to the county. They review all this. They still find against your clients. You come back up on appeal again, and you find another statutory provision that they did not comply with. Isn't that the whole purpose of why your arguments have to be made in the first instance so that the entire case can be decided and the entire case can be heard on appeal?
Are you meaning that by first instance, Your Honor, before the county commission?
No, I'm meaning right now, I agree with you that they didn't comply with the statutory provision. We send it back, we require them to do so. But even after that is done, they rule against you and your clients, and so you appeal again. And then on appeal with me in 4 years, you find another statutory provision that they did not comply with. Then do I have to send it back again? I mean, how often do you get to do that before the waiver of your argument is a concern?
Your Honor, the issue in this case is we were barred in 2015 from proceeding because of the county's interpretation of a statute. We appealed that interpretation. When it came back, they did not follow the statute again. And because they didn't say we had to have an accurate map. I mean, we cited that throughout our brief. And this is simply the next section of that statute. I understand what you're saying, and I believe, I'm a firm believer in finality, Your Honor. I just don't think we're at that place. I mean, you have the ability, if you wish, to require briefing on this issue, but give the parties an opportunity to brief it. But the bottom line is, the core issue, it's more explanatory than anything. It shows why the county and provisional government of Santa Teresa couldn't resolve this. It's because the proper process wasn't followed. And I wouldn't, it's not my duty to follow the statutory process of how to handle a petition for a corporation. It is the county's. And I hope I've answered the question. The facts, you understand the facts. This is the first time I've raised that argument under Section D.
And prior to moving on to the motion to dismiss, did you make any additional arguments in rebuttal to the arguments that were made?
Yes, I do, Your Honor. First and foremost, I want to point out after the arguments that I was bringing up a brand new argument, then Mr. Edelman spent a considerable amount of time bringing up a new argument in regard to stay, and essentially making a threat that there could be damages available against Mary Gonzalez and P. Ghost on this appeal. And it just is inappropriate, Your Honor, to argue that now. It is the state law on prior jurisdiction doesn't require a stay. It simply says you, Sunland Park, cannot move forward with an annexation if there's a pre-existing incorporation. There's no need for a stay. It was never argued before, and it was brought up today. And I just think it's inappropriate to essentially say, well, we want Mary Gonzalez to be here because she's the one that might have to pay for damages. There's no damages available in this case for appealing under our right to appeal with good grounds for that appeal. In Mr. Gooden's argument, Sunland Parks and Socorro Partners, essentially their solution is that the court just ignore that there's a pending annexation, and we'll figure that out later. That is not the appropriate path. Speaking of having to come back to you again, while I enjoy spending time with you, I don't think it would be as much fun as having a beer, but if we have to come back here in 4 years, it certainly wouldn't serve the parties. And the only way to get to finality here, because of Sunland Park's annexation, that's the issue, Your Honor, is they went ahead and annexed, saying, well, we don't think you're right. And that is what's causing the delay. But until that occurs, they're asking as if it's a simple task by a group of citizens attempting to incorporate to do the work for this incorporation and come up with all the governmental services at this time when they don't know what they're incorporating. And I submit that that is what is arbitrary and capricious, Your Honor. I did not mean to imply, as Mr. Gooden stated, that there was a nefarious motive by the county. I don't think there was at all. I just don't think that they applied the proper standards in this case, and they put the cart before the horse and didn't wait until the annexation case was concluded. And in regard to the final argument that was made by Mr. Morazzo, that somehow, and we'll address, I won't get into the arguments about whether PGOST is a proper party or not, Your Honor, until that comes up. But the thing that he brought up was basically saying that this request for continuance was improper. And it is not unusual. It was applied for 10 days ahead of time. They couldn't set a different hearing on it, but it was the first issue dealt with at the hearing, appropriately so. So there's nothing improper about the request. And the 90 days that they asked for after the Court of Appeals decision was assuming there wouldn't be a petition for cert on the Court of Appeals decision. And then they would have known what they were dealing with. These parties want them to spend a whole lot of money preparing for an incorporation argument and create new plans when these citizens don't know what incorporation they're going to be dealing with at that time with the pending annexations. So for that reason, Your Honor, I'll conclude my argument on that unless you have any further questions.
I do not. Thank you. Thank you. Mr. Gooden, if you would take up the motion to dismiss.
Your Honor, if I might, before that, just one brief response to this issue about the review board and whether the new argument that was raised. It's being argued that 321 requires the commission to send this petition up to the review board, and they would make this review as to whether or not the municipal services is adequate. It's basically what's argued. But if you look at section 325, the duties of the county commission after a petition is filed. After a petition for incorporation, together with the accompanying map or plat, the municipal services and revenue plan have been filed with the Board of County Commissioners. Board of County Commissioners, in lieu of complying with section 315, which is really not an issue, shall determine within 30 days after the filing of the petition, various items that are listed. And then it also says, or one of those items is to determine if the territory proposed to be incorporated is within an existing municipality or within its urbanized area. And then it says, if it determines that this is in subsection B, if the county commission determines that the territory proposed to be incorporated is within an urbanized area of the municipality and in compliance with 323, the Board of County Commissioners shall accept the data provided by the University of New Mexico, geospatial population. Then we go back to 323. One of those items under 323 is to determine whether or not they can provide, the proposed incorporators can provide the municipal services sooner than the municipality can. So that is a burden and a duty that exists with the BOCC, even in light of the amendment of 321 that created the review board. So I appreciate the court letting me to bring that up, again, on that new argument that was raised. As to the issue of the motion to dismiss provisional government of Santa Teresa not being a proper party, I've outlined that in my brief. And basically, the statute 325F provides who can appeal a decision of the Board of County Commissioners, and it is the signers of the petition or municipality within whose urbanized area the territory proposed to be incorporated is located. So it has to be a signer of the petition that has the ability to appeal. The Provisional Government of Santa Teresa is a nonprofit corporation, and they never signed the petition. So I think just from that standpoint alone, they are not a proper party. Provisional Government of Santa Teresa would not have been allowed to sign the petition because the petition can only be signed by qualified electors. A nonprofit corporation is not an elector. And so that's a very simple argument, but that's basically our argument. One of the arguments in the response was, well, they've been in this case for a long time. Well, shame on me for not raising it before. They've been in there a long time. Went to the Court of Appeals with that as well. Also, in prior cases, there was the Concerned Citizens of Santa Teresa in 1990, and they were allowed to remain in. But there was never a motion made to dismiss them. So the Supreme Court in that case entertained their arguments. But I think in this case, they're not a proper party. They're not a signature to the petition, and therefore are not a party who is permitted by statute to bring an appeal.
Anybody want to argue that on the side of the county prior to Mr. Atio replying?
Nothing from me, Your Honor. I think it's really straightforward application of the statute, as Mr. Gooden has said.
Mr. Atio?
Yes, Your Honor. I think it is at this point inappropriate to raise it by Mr. Gooden when what we're talking about, we're not talking about a group of citizens that wasn't involved in this case. P-Ghost is made up of the citizens of Santa Teresa who were attempting to incorporate. It is a important part of the point. I don't disagree with the statutory interpretation. Mary Gonzalez filed the appeal. At the very least, these P-Ghosts could have entered as an interested party and participated in this case. So it's kind of an interesting argument to say, well, they never should have been in this case, but they weren't objected to when the citizens of Santa Teresa were there at the hearing, and P-Ghost essentially was the members of P-Ghost were making the argument below on this petition process for the entire time. So I don't know why at this point the county thinks it's a good idea that P-Ghost not be a party to it, but I think that they should remain a party because it was not raised until the 11th hour and not raised below when the people were participating of who was opposing who was there speaking in favor of the incorporation. And at the very least, if the court does believe that they do not have the jurisdiction because they're not a named petitioner, then they should be allowed to continue to participate as an interested party.
Any reply?
Your Honor, if I just may ask, this motion was filed before our intervention, so we didn't reply and are not, I suppose, formally part of it. But if I'm allowed to say a word, I will, and if I'm not, I understand and I'll be quiet.
I would object to that, Your Honor.
Okay, understood. You may make your argument though, Mr. Morazzo.
Thank you, Your Honor. This is an argument that I have raised consistently in all of my briefing and all the cases that I've been involved. And the court orders and decisions of the courts of appeals, for one reason or another, haven't dealt with it. Cases seem to be decided on other grounds, but it's been brought up consistently for a long time. The provisional governor of Santa Teresa is not here in the position of an interested party. It is not asserting any right, standing, or arguments or positions of an outside interested party. It is pretending to be a signatory of that petition. It is pretending to be a body that will eventually become a municipality. And as I pointed out earlier, that is not the case. Its position, it's identical to Ms. Gonzalez's position. And for that reason, they're not an interested party, and they may be a party with any interest in this, not saying that they would be, could assert that interest, but that's not what's happening here. What it is, Your Honor, is that this entity has the term provisional government, and there's no such thing. There's no such thing. It almost seems in the cases and the proceedings as though they will become the municipality. That's not the process. They will not. There would be an election if they proceed. A municipality then is formed. This corporation has no interest in this fight any more than any other nonprofit corporation out there, to which residents could or could not be members, which, by the way, I'm not quite sure on this. They are the members of a nonprofit corporation, to my knowledge, doesn't have shareholders. It doesn't have members. It has leadership. It has a board, but no ownership interest in the actual corporation. So this is a matter of, I think, in my view, standing is, as I understand it, a component of subject matter jurisdiction. It can be raised at any time. This party is definitely not properly before the court. Thank you, Your Honor.
May I reply, Your Honor?
Yes, you may.
We aren't pretending anything. It's simple as that. This nonprofit corporation was created by the citizens of Santa Teresa to pursue the incorporation and to pursue the litigation that has ensued. It's for that purpose. Nonprofit corporations have been parties traditionally in New Mexico. And as we've stated, the Sierra Club has been given standing by our courts in many different instances to pursue claims. The issue here is, and I don't think there's anything that they chose to call themselves the provisional government. Obviously, that is not an entity that has standing in New Mexico. We never claimed that. I don't understand the argument to say that we are somehow misleading the court. That's certainly not our intent. That is the entity created by the citizens to assist them in this process by helping the citizens incorporate. And I just don't, it's a tempest in a teapot. And I want to circle back to one thing that I didn't get to respond to because I wanted to save time to respond to this argument, if I may, Your Honor. And that is both Sunland Park, Mr. Morazzo were arguing that, and Mr. Gooden has argued it all along, that the Court of Appeals created a different standard than in state statute, which was to provide services faster. That statement by Judge Bonhoeff was dicta in that case. That was not before the Court of Appeals. That entire interpretation was not litigated in that case. The statute speaks for itself, Your Honor. The plain language states that residents of the territory proposed to be annexed conclusively prove that the municipality is unable to provide municipal services within the territory proposed to be incorporated within the same period of time. So this idea that we had a burden to show this faster, and there is the language of the statute simply speaks for itself, and Judge Bonhoeff wasn't ruling on the interpretation of that language. Thank you.
Your Honor, may I just briefly respond to that last point?
No.
Sure.
It's 4 words. Law of the case. It's law of the case, Your Honor. This is the same case. We're all, just like the county was bound to follow the remand orders, we're all bound to follow the law of the case unless overturned by an appeal court. That's all I have to add, Your Honor.
Are we bound to follow dicta if it's from the appellate decision?
That I think the answer is yes, actually. Now again, if this was a different case, no.
Yeah, if the dicta went against your client, then
If it's law, I think if an appellate court says do this, even if it's dicta, I think so. I can look it up and find. I don't know. I don't know that. I don't have any case law to support that, Your Honor. But it's law of the case as opposed to dicta in another case from a controlling court. You're not bound to follow. But in the same case, I think the law. I think the law of the case doctrine applies there. But I also I've made my pitch. That I don't need to go any further.
understood.
Sorry, Your Honor. If I
Any
could say
additional? Go ahead, Mr. Morales.
Yes, I'm just going to read from the conclusion paragraph of the Court of Appeals. It says, we remand this action to the district court to reverse the county's decision and instruct the Board of County Commissioners to address the PGST's claim that it can provide municipal services more quickly than Sunland Park, and whether PGST's petition otherwise satisfies the requirements of 3-2-129. That's the instruction. I don't think that's dicta, and that's what the county did.
That's a pretty good argument, Mr. Morazzo. Mr. Audio, if it's in the actual decretal order, even if it's an interpretation you don't think is correct, would it no longer be dicta? Would it not be binding on this court and the county commission?
Your Honor, I would say 2 things. One was, there was not a holding of the court that was the meaning. It was not litigated what the meaning of that phrase was. It wasn't before the court. I think the court was stating that apply the standard. And I have not researched whether or not in a mandate, if the court misstates the statutory standard, that the county would then apply an improper standard. So the fact they've put a lot of weight on this, Your Honor, but I simply don't think that the court in its mandate can change when the issue did not come before the court, the meaning of a statute.
I appreciate everyone's arguments today and the briefing on these matters. It is a whole record review, and that review has certainly been undertaken by me to a significant degree, but not a conclusive degree, because I wanted and felt it was important to allow the parties to make their arguments today. So I will not render a decision on this matter today. Take it under advisement, issue a written ruling explaining the decision so that the parties hopefully can have some clarity in my thought process. And I will attempt to do so in a timely manner so that whatever processes continue in this case, either at the appellate level or at the remand level or just in the other case, will not be hindered by me.
Thank you, Your Honor.
Thank you, Your Honor.
Well, have a wonderful morning, and again, I do appreciate all the work.